Good afternoon and welcome. I'm Elizabeth Slattery, Vice President of Practice Groups at the Federalist Society. Thanks for joining this conversation about the FACE Act, its recent enforcement, and the constitutional and policy questions surrounding its future. As always, our usual disclaimer applies. The Federalist Society does not take policy positions, and all views expressed in this session belong to our speakers. Toward the end of the webinar, we'll take questions from the audience, so please think about your questions for our panel. Use the Q&A button at the bottom of your screen in Zoom to ask a question. Now I'm pleased to introduce our impressive panel of experts. I'll keep these short and sweet so you can hear more from them rather than me, and you can read their full bios on our website. Matthew Cavadin is the Director of the Project on Criminal Justice at the Cato Institute. Jeremy Dyes is Senior Counsel at First Liberty. Aaron Hawley is Supreme Court and Appellate Litigation Chair at Lex Politica and of counsel at Alliance Defending Freedom. And moderating today's discussion is Casey Maddox. He's Vice President for Legal Strategy at Stand Together and Vice President of Legal and Judicial Strategy at Americans for Prosperity. Casey, take it away.
Thank you, and thanks. Thanks especially Elizabeth for hosting us. Thanks to the Federalist Society. And thanks for the panelists for joining us for this conversation. This is going to be an interesting conversation about the FACE Act, especially over the last month or so, maybe 6 weeks or so. The FACE Act has come back into public consciousness because of what transpired in Minnesota around the ICE protests and in the arrests of a number of people who were protesting in and around and in a church in Minneapolis. Don Lemon, of course, was one of those people. And so this has prompted a lot of conversation about the FACE Act. What exactly is this law? It's a very strange law because of the coverage of this law. You don't have a lot of laws where the coverage is houses of worship and reproductive health facilities. And so we will discuss, I think basically the idea for this conversation is we want to talk about a few things. So the basic structure to sort of guide you as you listen, that questions are in fact coming, would be the constitutionality of the FACE Act, sort of the FACE Act on its face, right? The big, broad questions about the constitutionality of this law in the first place. And then we will talk some about the FACE Act in practice over the last 30 years or so, how it's actually been enforced. And then we'll talk about the specific application of this law in Minnesota in these cases. So I'm going to start just by going through the panelists, let them introduce a little bit of themselves, their perspective, general perspective on the FACE Act, and then we'll come back and kick off the questions. So, Jeremy, you're the first one on my list, so I will let you kick it off.
Well, thanks, Casey, and thanks to the FedSoc for allowing us to participate in this. The FACE Act, as Casey has sort of highlighted, is a unique amalgam of a few things. But we got to go back in history to a time when Casey was just a mere president of the Future Farmers of America in high school, and there was a debate at that time about whether or not we were going to be, over the issue of abortion. And things have not exactly gotten better since then, but there were certainly a lot more violence and talks of violence at that time. And so Congress acted by producing the FACE Act, and that's an acronym for the Free Access to Clinic Entrances Act. And it largely protects, just in general matter, it's at 18 U.S.C. 248, if you want to look it up as the lawyer nerds that you probably are listening to this call, 18 U.S.C. 248. And generally it says that if you're going to intimidate, injure, or interfere with access to a reproductive health facility, or those seeking to access a reproductive health facility, you're going to be subject to certain penalties if you do so. That means you're going to have the potential of the Attorney General of the United States being able to file both criminal and civil charges against you. The Attorney General of the state in which you live has a private right of action to bring enforcement on behalf of the citizens of the state as a parent patriae sort of a lawsuit. But then also individuals that are aggrieved under the act are permitted to bring a civil suit also against the perpetrators of that type of, again, injury, intimidation, or interference with access to a reproductive health facility. Well, in the middle of this debate also at this time, back in the early 90s, Senator Orrin Hatch, who himself a very pro-life proponent, was also very concerned about what this would mean with our nation's houses of worship, or perhaps he was hoping to add a little bit of protection for them as well. And so, in addition to protecting reproductive health facilities, he instituted a section in A2 that protects our nation's houses of worship. And so that provision is very similar to the other provisions for reproductive health facilities. It says that if you intentionally interfere with or intimidate or injure someone seeking to exercise their free exercise rights at a place of worship, or if you attempt to do so, you are also subject to the penalties of the FACE Act. And so for the last however many years that's been since this act was adopted in 1994, the law has sort of been a bit of a ping pong for the, or maybe a foil, better way to put that, for the pro-life versus abortion debate. And largely the history of this has been that it has been enforced negatively against the pro-life community and almost not at all for houses of worship. In fact, the very first time that the law has been utilized on behalf of a place of worship was this past year in September of 2025, when the Trump administration filed a lawsuit in West Orange, New Jersey on behalf of a synagogue that had been agitated against by those seeking to injure, intimidate, or interfere with access to a place of worship up there. They previously filed a statement of interest last March as well, but those are the only two recorded times in which the government has actually instituted that. Now, I'm going to quickly add also, and I'll conclude my conversations with these two final points. Number one, we have also filed a lawsuit at First Liberty Institute, where I had the privilege of working on behalf of our nation's houses of worship on protecting their religious liberty. We have filed a lawsuit on behalf of the Christian and Jewish Alliance and Mission Church in San Diego, California, where during an event at their church on a Wednesday evening, protesters, agitators, clandestinely purchased tickets under assumed names to be able to attend the packed out event of about 500 people inside the sanctuary. And during the middle of the event, at which a former member of the Knesset was speaking to the group's audience there, began to pop up and yell loud phrases and agitate for a variety of different things. They had to be, in some cases, dragged out of the facility. And when members tried to leave the facility down the two steps that would lead them to the public sidewalk out the front door, they were met with a crowd that had everything but the pitchforks and the torches out front, yelling, screaming, cursing, calling Nazis, you know the bit. They were interfering clearly with access and certainly with egress from the place of worship there in California. And so we have filed that lawsuit. And in fact, we'll be making additional filings even in the next 24 hours in that case in California. The second case that we've applied in this situation, and with this I'm done before I turn it over to my co-panelists, after the Dobbs decision came out, we all know the violence that erupted across the eastern seaboard of the United States directed at pro-life pregnancy care centers across the country. And there were some 100+ instances documented of, in some cases, Molotov cocktails. Other things were spray paint, very violent phrases being issued, threats and warnings against pro-life people of faith that were simply trying to provide expectant mothers with diapers and baby formula and knitted blankets and this sort of thing. And yet they had to go through a gauntlet of sort of terrorized phrases in order to access these services at pro-life reproductive health care facilities. And so, along with then Attorney General Ashley Moody, she's now a United States Senator, we provided a lawsuit on behalf of Heartbeat of Miami, a pro-life reproductive health facility in Hialeah, Florida. The Attorney General filed her own enforcement action in addition to that. And in one small but very bright star in the Biden administration's favor, they also filed a criminal charge under the FACE Act against the folks associated with Jane's Revenge who had brought those violent tasks there. Now, there's a lot of debate that we can have about that, and I think we need to have that part of the debate, but that has been my personal experience with the FACE Act and a helpful overview of the FACE Act itself.
Excellent. Thanks, Jeremy. And Matthew, we will come to you next.
Thank you very much. Jeremy wanted to go back to when Casey was in high school. I want to go back to when Casey's great-great-great-great-grandfather was in high school after the American Civil War. Congress passed, as part of the Reconstruction era, a measure to make it a federal crime to interfere with anybody's rights that are constitutionally protected. And there was a Supreme Court case that struck that down as exceeding Congress's authority. The Supreme Court said that the principle of federalism means that most police powers are exercised at the state level, not at the federal level. Fast forward to the modern era, Now, in order for there to be a federal criminal law governing some sort of conduct, it has to fit within an enumerated power. The two big ones that tend to come up in conversations like this are the Commerce Clause and the 14th Amendment, Section 5. There's a problem for the FACE Act under both of those. Under the Commerce Clause, activity has to be economic and has to be related to interstate commerce. You can stretch your imagination and say, well, if you have people who are protesting inside of these facilities, then people might be less likely to visit them, which could impact their lifetime earnings. Except the Supreme Court in the 1990s junked that logic in two cases, one of which made it a federal crime to commit violence against women, and the other of which made it a federal crime to carry a gun near a school zone. The Supreme Court said that is not closely enough related to commercial activity in an interstate context to justify a federal criminal law about it. The other big problem here is Article 14, the 14th Amendment, Section 5, gives Congress the authority to enforce the Equal Protection Clause, due process, and privileges or immunities using appropriate measures. That means that Congress can step in order to enforce people's rights. However, the Supreme Court has said there's got to be state action. There has to be something that a state is doing, that a state government is doing. The Supreme Court case back in the Civil War, post-Civil War era that I have in mind here was about the rise of the Ku Klux Klan, overwhelming the ability and the willpower of state law enforcement to do anything about their campaign of terror. And the Supreme Court said that was not good enough to justify federal action. I am part of the unconventional opinion that the civil rights cases back then were actually wrongly decided. But even though I have a broader sense of what the 14th Amendment lets Congress do, I still say, based on other precedent, there's got to be some sort of breakdown in state enforcement. The Supreme Court said that in the violence against women case and in the school gun zone case. The Supreme Court was looking for, is there a record of states failing to do their jobs, failing to provide for protection for rights here? Given that there was no record compiled, the Supreme Court said this is not something the federal government can proactively step in and criminalize. In theory, Congress or the federal government prosecutors could show that there is in fact a systematic failure to prosecute people who disrupt religious services. Religious free exercise is a constitutionally protected right. There could be, if there was systemic state failures to step in, Congress, I think, would have the legitimate authority under Section 5 of the 14th Amendment to pass legislation to step in where the states are failing to do so. Whether it has done so or not is an empirical question that hasn't gotten tested much for a lack of prosecutions and a lack of defense challenges to the FACE Act in the context of religious interference. I am skeptical, just at the gut level, that there's enough of a breakdown in law and order at the state level here that people are routinely disrupting religious services with total impunity from the states to justify this becoming a federal crime. So that's where I'm starting out with the FACE Act is I don't think it's constitutional because I don't see what enumerated power of Congress justifies it. I do want to say, well, one more piece of the unconstitutionality picture, and then I want to limit my argument. My argument certainly is not that the behavior that the protesters engaged in here is constitutionally protected, or that the First Amendment allows people to disrupt private religious services or to barge into reproductive health facilities. Private property rights matter, and states have every authority to go after people who are behaving in a disorderly way, committing trespass, refusing to leave when they're ordered to do so. States can absolutely respond to that with criminal charges, and it often is appropriate to do so. Nevertheless, the caveat here with especially the Minnesota arrests, the most prominent one is independent journalist Don Lemon. There's a factual question as to whether he was covering the event or whether he was helping to instigate it, whether he was participating in it. That is a close call. A magistrate judge actually rejected arrest warrants for him and another journalist, even while issuing them for several of the other protesters, based on concerns about that. The Department of Justice then took the highly unusual step of not only requesting the district judge to issue those arrest warrants, even though the magistrate hadn't, but then going to the Eighth Circuit Court of Appeals for a mandamus on the judge while he was deciding whether or not he had the authority to do so. None of that is dispositive. Don Lemon might well get proven guilty when the chips fall. Nevertheless, this is a pretty extraordinary posture for a prosecution, and I think it does signal that there are some issues here as far as whether he's being retaliated against for protected First Amendment activity or whether he in fact violated the FACE Act. One more brief statutory point. I said earlier the FACE Act talks about disrupting religious services and reproductive health facilities. The statute defines disruption as physical obstruction or other forcible activity. So even just being vocal and loud doesn't on its face make out a violation of the FACE Act. There has to be some sort of forceful, usually physical intrusion on that. So I look forward to hashing out all these issues more in this discussion.
Excellent. And I will say again, some questions are already starting to come in. I would encourage people to put your questions in the Q&A as well, and we'll try to get to as many as we can. Erin.
Sure. Thanks so much, Casey. Thanks for having me to the Federalist Society. Delighted to be here with all of you. And I really would echo a lot of what Matthew just said. I think there are serious constitutional concerns with the FACE Act on a number of fronts. As Matthew said, it's on really slim Commerce Clause ground, which is sort of ironic because after the Supreme Court's decisions in Morrison as well as Lopez, these are the cases Matthew referenced, then the court subsequently upheld statutes that have what's called a jurisdictional hook. And how a jurisdictional hook operates is it says something like this statute only reaches conduct that would affect interstate commerce. The FACE Act doesn't have that. It is flatly a federal criminal law provision that regulates non-economic activity. And as Matthew said, maybe you can cobble together enough of an economic activity to rise to the level of a substantial effect under which the court has looked. But the real question, I think, for purposes of the Commerce Clause determination is, as a constitution, where are these sorts of issues supposed to be determined? Do we want a federal crime for sitting peacefully in front of an abortion center? Is that what we want federal law to do? Or instead, is that sort of a quintessential state police power that we expect our states to protect private property, to protect the ability to peacefully assemble, to peacefully worship, and those sorts of things? So I think there's one thing I would add to the constitutional conversation is just the horizontal division of separation of powers. And are we really perhaps relieving the states of their responsibility to police and protect people and order in their own states? The other sort of constitutional issue that's going on in the background, in addition to the First Amendment and potential retaliation for First Amendment protected conduct, is this idea of selective prosecution. And this would be more of an as-applied challenge rather than a facial challenge to the FACE Act. But there is a significant question as to whether this statute has been evenly applied. Of course, sort of the basic rule of law is that a statute applies regardless of whether you are going after, in this case, if you are protesting at an abortion center or if you are protesting at a church. The law should be even-handedly applied. But if you look at the way that law has been historically applied, it has been dramatically targeted at pro-life individuals who have been protesting, most of them peacefully, at abortion clinics. So to take just a couple of examples, we have the example of Eva Idle. She was an 89-year-old concentration camp survivor sitting in the doorway of an abortion clinic. And under the statute's language, that counts as obstruction. So you can go to federal prison for sitting in the doorway of an abortion clinic. And in addition to this, the Biden administration did something really creative and also, I think, quite abusive in that they tacked on a charge for civil conspiracy. What that meant was that a nonviolent offense like Eva Idle's could be subject to up to 11 years in prison. So about a year, 6 months or a year for the FACE Act charge, and up to 10 years for the conspiracy to violate civil rights. So that ratchets up, it's sitting peacefully in front of an abortion clinic, exercising your First Amendment rights, and you could have the book thrown at you, federal prosecutors zealously going after you, and face an 11-year charge. So I think there's a host of problems with the FACE Act. And the historic pattern of using that statute to enforce it in a one-sided way, I think is something that should give us all pause.
So before we move on and focus more on the because I think we have covered a lot of the questions around the constitutionality. Before we move on completely to the application of the law, does the Dobbs opinion change anything with respect to this law? To some degree, right? You have this possibility that, like, well, you're protecting constitutional rights. When Roe was the law of the land, there was at least, arguably, well, then that's Congress's authority, Section 5, to enforce and protect equal protection, and that includes this decision. Does the Dobbs opinion change that dynamic at all? Congress's authority, to act in this way, or does that basically push it entirely back on the Commerce Clause justification now?
Well, since I raised the 14th Amendment earlier, I'll say there's no 14th Amendment hook at all if there's no federal right that's being protected. So now that there's no longer a federally protected right to abortion, I don't understand how there would be any sort of hook under Section 5 of the 14th Amendment for the abortion side of the FACE Act. I don't think it has any more rationale. Now, Constitution is one question and politics is another. One of my concerns is that after the Dobbs decision came down, there's a sense from certainly the current administration that the way to right the overreach and the wrongs that were committed under the FACE Act before is to now selectively prosecute in the opposite direction. I will call listeners to call to the attention of listeners. Jonathan Darnell had an op-ed last week in the Daily Caller. Jonathan is a pastor who was actually convicted of FACE Act violations under the Biden administration and was pardoned by President Trump. He wrote an op-ed and said, I don't want to see the FACE Act used against Don Lemon or against anybody at this point. That really what we have now is a moment where we can consider getting rid of the entire law altogether. We shouldn't just turn around and use it as a weapon against the other side, quote unquote, nowadays. Rather, we should use this as an opportunity to get rid of the law altogether. Is there the political will to do that post-Dobbs? I don't know. As of right now, the answer appears to be no, because we're seeing these prosecutions being brought.
Well, I'll pick up where Matthew leaves off there on that point. I don't hold much hope for the Congress to repeal the FACE Act if they can't even settle on a budget or whether or not you have to use a driver's license to access the voting booth. So I think that question is probably completely off the political table, as it were. And I'll put my further cards on the table because I didn't really address the constitutionality arguments that Aaron and Matthew raised, which, by the way, I'm very sympathetic to largely. But I think maybe I'm letting my practical side win out against my intellectual, academic, whatever side that part of me has to fulfill in this. Because the Second Circuit, the Fourth Circuit, the Seventh Circuit, the Eighth Circuit, and the 11th Circuit have all considered the FACE Act. They have all found them to be constitutional. And so the law is, as it is right now, constitutional with no dissenting opinion. There is no circuit split on this case. And so whether or not it is constitutional or not, that's a question for professors to be able to have the luxury to debate. And I would join them in that debate and probably share a lot of sympathies in it. But for right now, it is certainly constitutional, despite the inequitable application. And that's really what the argument, I think, comes down to. And again, I have lots of sympathy there. But at the end of the day, the law is constitutional, and we ought to be able to say, well, we're going to use that in a correct way, especially when the individual citizens are given the private right of action to be able to take that up. Let me give you a couple examples of what I mean by that. And here's again where my sympathies are, that I do think this has been inequitably applied. In fact, after Dobbs, there were a number of new Massachusetts pregnancy care centers that were vandalized. They had bricks thrown through the window. They had intimidating spray paint, just a whole bunch of terrible things there. What did the Attorney General at the time do? Did she open up a tip line to find out who these people were? Did she do an investigation? Did she send out the resources to protect them? Of course not. Attorney General Maura Healey, who's I think now the governor, instead she went after the pregnancy care centers. She accused them of misleading information and false advertising and a litany of other things. Didn't have the common decency to even ask if they were okay. Instead, she went after them with the full force of the law behind her. Rather than utilizing the FACE Act to protect the citizens, all the citizens, she went after a subset of citizens instead. I think the same thing is probably very true of the Biden administration. Now, I don't know how many different kinds of cases went out there, but my suspicion is, and it has been for a long time, that the very indictment that led to our ability to file a lawsuit on behalf of our pregnancy care center down in Florida under the FACE Act was a political homage to the issue, that they felt such political pressure, the Biden administration did, that they had to do something to sort of balance the equities that are out there. Well, look, if that's true, and I'm willing to grant that it is true, that there has been inequitable application, my guess is there's been something like 200 different prosecutions under the FACE Act since it was enacted, and maybe 10 of them have been on behalf of or in protection of pro-life, the pro-life side of the equation. And we know now only 1 or 2 on behalf of churches that have been instituted. But if that's all true, and there is this great inequality that is out there, the solution to that is to stop being disequal. But I don't have a lot of hope right now that we have someone like Attorney General Moody in Minnesota or California. I very much doubt that Attorney General Ellison or Bonta are going to join my lawsuit in California, for instance, or the federal government's lawsuit up in Minnesota, but they should be ashamed of themselves for not doing so. Here you have a duly passed law by Congress. You have the Attorney General that is authorized in every individual state to bring actions on behalf of their citizens, seeing the very clear inequality that's been produced there, seeing the injury, the intimidation, and the interference with access to, or even just the attempts to, as the statute points out. These attorneys general have turned a blind eye against the law. They have taken off the blindfold of justice and decided to put their finger on the scale instead on behalf of their political friends. They should be ashamed of themselves. Instead of doing so, they should bring a lawsuit on behalf of all the citizens of the state of California, and in our case, or in Minnesota, to protect everybody. Why? Because if you're going to pick up a brick to express your disagreement, you ought to be prosecuted under the law and held accountable under the law.
Well, and I think a lot of people responded. We will eventually, or shortly, we will get to the Minnesota specific questions. But a lot of people have raised the obvious point that this feels like just, I mean, first of all, the Minnesota AG could enforce the FACE Act and enforce it only against the people that he thought it needed to be enforced against. But also there are other state laws that would have been implicated, right? I mean, there are trespassing laws and all kinds of other laws that are probably your sort of garden variety state laws that are that were implicated by what happened there. And a lot of the response from people has been, well, why aren't those, these FACE Act prosecutions are bad because those laws are the ways this should be dealt with. And I think part of the challenge is right, but we're not seeing those laws enforced in some of these situations. Aaron, I'll come back to you just for kind of wrapping up on this kind of FACE Act in practice question. What can we do about this reality, right? You've got sort of the concern, I think, would be that with a law that has 2 very different constituencies that are covered, that with very different political valences for them, that you would end up with basically in red states and during red presidential administrations, the law is enforced one way and not in the other way. And during blue administrations and in blue states, it's enforced in the opposite way. And that does not feel like, if it's one law, that doesn't feel like a very satisfactory way for the rule of law to be operating. What can we do about that fact?
Yeah, I think that's a great point, Casey, and it shouldn't sit well with any of us on either side of the political aisle for sure. Just to look, since we have all the data from the Biden administration, since just 2021 to the end of the administration, it charged 24 FACE Act cases. 22 of those were against pro-life advocates. So just a huge disproportionate use of a federal statute, in addition to what I mentioned earlier about tacking on this additional conspiracy against federal rights charge, which had never been done before, but meant that these garden variety protesters were subject to lengthy prison sentences, federal prosecutions. And if you think about the case of Mark Hook, he was the Pennsylvania authorities determined not to prosecute him. And yet the Biden administration made a federal case out of that. So there should never be that sort of disparity in how it is enforced. And I really take Jeremy's point that we are seeing a lack of protection for pregnancy care centers in some states. In fact, blue states, New Jersey has been a particular offender, are going after pregnancy centers instead of protecting them. California, New York have done the same, suing pregnancy centers, again, instead of protecting them. But I'm not sure the answer is to use a law that has such a historical pedigree of being one-sided, especially given the constitutional concerns. Again, we have a federal government of limited laws, and we need to have a constitutionally enumerated purpose. So I think the FACE Act is on thin ice. If it's going to be enforced, it 100% should be enforced equally, but we have not seen that, at least as a matter of historical practice.
Let me
Okay,
chime
so
in.
I can't resist. Speaking of ICE, I'm sorry. My apologies. Speaking of ICE, let's talk about Minnesota and the application of this law in Minnesota specifically, which I think will actually probably still include some of the conversation we've been having. But Matt, we'll come to you actually on this, and feel free to fill in anything else you were about to say there as well. But on Minnesota, as you look at the application of this law in Minnesota, kind of what's your reaction to what you've seen so far in terms of the facts and how they match up with what the law actually says?
Real briefly, I do want to respond about some of the factual concerns, and I don't know the numbers on these things, but attacks on religious liberty sometimes take the form of either arson attacks or attacks on individuals. Those are separately prosecuted under federal law, under arson charges or hate crime laws. There's no analog for that in the reproductive context. So I do wonder how much there's a lack of FACE Act prosecutions because some of those issues are being dealt with using other legal methods. I'm not saying that that's empirically true or not. I just do want to point out that that does exist. I mean, if somebody gets assaulted on a street, for example, for practicing their religion, there can be charges brought under other parts of federal criminal code for that. As far as the use of this goes in Minnesota, when we have laws that broadly criminalize things like conspiracy, like obstruction, certainly the FACE Act on its face covers disruptive behavior. These are really broadly written, and they are terms that require a lot of finesse to figure out what exactly is covered versus what isn't. That's a lot of what we're seeing with Don Lemon's activities in particular. He was there. He appears to have had advanced knowledge that it was going to happen, that there was going to be this protest at the church. He showed up and live streamed it. I don't know whether he laid hands on anybody. There's a lot of wiggle room for determining who's going to get charged based on what evidence. Does it have to be only the people who are caught on camera? Things like that. Those are concerns, by the way, that came up a couple of years ago with the January 6th riot at the Capitol, right? Was some people were attacking police officers with fire extinguishers. Other people were not. And when you lump in everybody together under these broad federal conspiracy charges, you have a bludgeon. We do know, based on the administration's approach to immigration enforcement and statements from administration officials, there was a desire to hammer Minneapolis into submission, to punish state and local officials for what was seen to be recalcitrance toward immigration laws, to punish local activists who were deemed part of a national Antifa terror network. And so there was this desire to bring all of the tools out and use them to bludgeon folks. One thing that did not come up yet in our discussion is the difference between going to federal court for, say, sitting in a clinic entrance or protesting near a building versus having state charges brought. State charges for disorderly conduct, you're going to get a tap on the wrist. Federal, anything federal, is going to get the full resources of the Department of Justice and is much likely to result in a stiff sentence. Indeed, Aaron brought that up in the context of some of the FACE Act prosecutions on the pro-life side of things, right? You had people who were engaging in minimal behavior, but were facing 11 years in federal prison as a result. I remember some years ago hearing about somebody who had a public indecency, and it happened to be on federal property, getting a year and a half in custody for that. That would never happen at the state level. All right. So when we want to talk about a complete picture of what was going on in Minneapolis, yes, the FACE Act and the conspiracy charges that were related to it, just like in the pro-life context, were used in order to threaten people with huge amounts of federal prison time for activity that, even if you had a diligent state or local prosecutor, would never get those kinds of consequences in a state court.
Jeremy, I'm curious if you've got thoughts on one of the arguments has been, and this is actually could be for either Jeremy or Aaron. One of the arguments that I've seen is that, well, no, but the FACE Act only prohibits actual like physical disruption of the facility or blocking the entrance. And so the argument has been that the facts here just don't really match that what was happening was people who had the ability to enter, right? So it wasn't trespassing even in that sense. They were permitted to enter. They were engaged in activity that they weren't supposed to be or that wasn't welcome. And then that Don Lemon ultimately is sort of holding someone, but he's holding them by asking questions, and other people are blocking the exit. How do you? What's your for either of you your thoughts on sort of lining up the facts that happened in Minnesota with what's actually prohibited in the law?
Yeah, no, I think the facts are fairly easy to apply to the law here, because the law is quite solicitous when it comes to protecting those who are, and I'm quoting from the law, any person lawfully exercising or seeking to exercise the First Amendment right of religious freedom at a place of worship. So there's no question this is a place of worship. It's a church. It's the middle of the high day of the week for Christians. They're in the middle of their Sunday morning church service. The prayers were going on. The Bible reading was happening. The sermon was about to be delivered. And in walk not protesters, but those who are seeking to cross the line between, which I acknowledge is the fine line between rightfully being able to protest someone and agitating through intimidation or interference and all the other things. There's no question that they've engaged in, again, what the statute calls interference with any person trying to lawfully exercise. The people were there gathered lawfully to exercise their First Amendment rights to worship. And these people were trying to clearly intimidate, or I'm sorry, to interfere with that. In addition, they were also trying to intimidate these people. Why? We have it on video, seeing these folks yelling and screaming at moms trying to go get their kids from the nursery. And they weren't even allowed to do that. So they're intimidating them with loud, angry phrases, calling them all kinds of expletive-laden names and false accusations against these people. So they're clearly an effort to intimidate them as well. But they're also there to make an attempt to injure them. Well, they couldn't leave. They couldn't. Put yourself in the situation, if you will, for just 1 second. You're sitting there in a normal Sunday morning service, and in walks a crowd of angry, yelling, screaming protesters, agitators, whatever you wish to call them, people who are violating the law by being there. They surround your church. They act as a human shield between you and your children. Now, I don't know about everybody else in this call. I suspect they share the same view. Hell nor high water is going to keep me from running through that human gauntlet to get my child and get them to safety. Some of the people tried to do the very same thing and were prevented from being able to do so, at least momentarily. And that is enough under the statute to hook them into the protections and the resources of the federal government, protecting their right to lawfully exercise their First Amendment freedoms. One individual, I understand, also tried to leave the facility, but a protester put themselves in between them and the exit such that they had to alter their course of egress. They tripped, fell, and broke their leg. Well, now we have a clear injury that has occurred as well. In the case of our situation down in California, not only did I didn't describe one of there was a Wednesday night service, which I did describe, but there was also a secondary service at a local amphitheater where protesters, again, surrounded with bullhorns and sirens and all the other kinds of things, people trying to access the event while people were walking back and forth slowly across the driveway, preventing access into the parking area. Many people, hundreds of people, as a matter of fact, left and didn't even try to attend the event. That's interference, again, with access to a place of religious assembly for those seeking to lawfully exercise those rights. Protesters that would come up to people trying to gather there. One person was driving in, and an agitator jumped on her car and beat the windshield, yelling and screaming and calling this Jewish grandmother a Nazi. I mean, great irony there, right? and horrible things that will just traumatize any lawful person trying to exercise their First Amendment freedoms. Others were standing near the protesters with bullhorns, had the bullhorn turned up to 11 directly into their ear with sirens blaring. The person had ringing in their ears and auditory damage for weeks at a time. And so the only way that these people are going to get any kind of protection, especially in a time in a place like California, where the police were there and elected to do nothing on the behalf of the people lawfully gathered to exercise their religious freedom in California, also in Minnesota. But in our case, especially, the police did nothing. Attorney General Bonta will do nothing to be able to hold these people accountable for their unlawful actions against people of faith trying to peacefully gather for religious worship. The FACE Act and groups like First Liberty Institute may be the only means by which they have any kind of recourse to protecting those rights and sending a message. Again, if you're going to pick up a brick, a can of spray paint, or a bullhorn to express your disagreement, you had better be careful, because there are federal protections within our civil rights laws in these United States that guarantee that First Amendment freedom to be able to lawfully gather without you having to face an angry mob that is engaged in unlawful, illicit behavior.
I'm going to come back to Aaron. You can feel free to comment on anything else you just heard, but also wanted to ask you the question, the Don Lemon specific sort of constitutional question that I think some have asked, which is basically this concern about, well, but he's a journalist, right? He's a journalist, and so that was, I think, even part of the initial objection from the magistrate, and that a lot of people, I think, are concerned about. How should we think about that? Now, I'll begin just by saying I think one of the challenges, of course, is always that you get this press protection in the First Amendment that people sort of perceive of as being, there's a certain category of people who are blessed with this particular right, and they get to walk around with that right that the rest of us don't get to have because we don't have a license or a credential that authorizes us, right? That's not what the thing is intended to be. But how do we think about that sort of, the interface of the FACE Act with Don Lemon and his sort of role in the media, whatever it is?
Sure. So first, real quick, to respond to something that Jeremy had said, is he did a great job of laying out some of the facts and some of the feelings that one might have felt if you had been in that church service. And I just wanted to compare and contrast it to a religious liberty, a pro-life demonstration that took place at an abortion clinic in 2021 in Mount Juliet, Tennessee. 11 people were charged in that incident. They were in the hallways. They were singing and praying. The Biden administration alleged that they blockaded the door and prevented one patient from entering. That sounds pretty mild as compared to what we saw in Minnesota. So again, if we're going to have a FACE Act, it has some constitutional concerns, but we should at least apply it even-handedly. The only other thing I wanted to say too is I saw in the comment a question about whether the lack of prosecutions for pro-life pregnancy care centers and churches could be because those just aren't targeted as much as abortion clinics. The absolute reverse is true. After the leak of the Dobbs decision, hundreds of churches and pregnancy centers were targeted. They were with Molotov cocktails, with bricks, as Jeremy said. So there's no question there was sort of a range of violent activity against those, and yet we saw that disparate prosecution. Now, to get to your question finally, sorry, Casey. So I agree with you. Just the fact that you have a press credential doesn't give you a right to violate the law. So I think the question really turns on, as Matthew indicated, I think in his opening, was, what was Don Lemon doing? Was he simply reporting? Was he standing to the side? Was he reporting on it? That seems to be a very different factual situation than if you are sort of part of the situation that is blockading access, intimidating, and disrupting worship service. So I think that's really a factual question.
Yeah, I've asked people before to imagine a circumstance like, fortunately, the way this law is constructed, it allows for very easy hypotheticals to put the shoe on the other foot and allow people to be able to see how this would work, right? If you had, Life News live streaming, and they're inside of an abortion clinic and they're live streaming from inside the abortion clinic, and take off the table that they're not showing HIPAA information, so let's take that out. But in that circumstance, right, is that press? Is Life News press if they are there and are live streaming on X?
Well, and if I can jump in on that, Casey, you're right to compare both sides of the equation. So let's take my reality situation. In our case in California, let's say that someone is trying to access a Planned Parenthood clinic somewhere else, and an abortion, or I'm sorry, pro-life protester, agitator, whatever you want to label them as, and I don't mean to be pejorative in the slightest on that. Let's say one of them jumps on the hood of the car of the young lady that's trying to access that reproductive health care facility. Are we saying then we should just simply, in the exact same way that the agitator did in California to my Jewish grandmother who's trying to access her place of assembly for religious worship, are we saying, well, we're going to need to be pure about this and not apply the FACE Act because we think it's unconstitutional? And it very well may be. I don't understand that logic at all. I would be in favor of going after the person who jumped on the hood of the car, regardless of whether they're doing it from a pro-life perspective or someone who wants to stop a Jewish grandmother from going to a place of worship. Now, where we find agreement again for my friend Aaron Hawley and I is that the law has not been faithfully applied to one side or the other, and I completely agree with that point. But the answer is to say, look, is not to say there may be a stick on the ground that the religious liberty folks can pick up and use against those who are trying to stop the lawful exercise of that First Amendment freedom, because we've got pure reasons for doing so, even if I agree with those reasons. That can't be the situation. If the law is there and you're saying I have to just simply give it up because, well, we've got to abide by these Commerce Clause questions, I'm sorry, I can't go down that path. I'm going to protect our houses of worship and their right to be able to exercise freely without having a brick thrown through the stained glass window or having someone else jump on the hood of the car trying to walk into that facility. We should apply the laws equally, and all of us, and I think we can all find agreement here, we should all be rightly condemning Attorney General Bonta and Ellison in Minnesota and California for their failure to act here, either on the local level or on the the support. They have a right of action under the FACE Act to bring a lawsuit that would produce multiples, well, it's tens of thousands per incident. So every one of those people would be meeting a minimum of $10,000 of penalties that are non-dischargeable in bankruptcy. And that would be on top of everything else that could come under there from the federal prosecution of the case and the individuals that every person in that church has a right under the FACE Act to bring their own lawsuit against Don Lemon and all of his cohorts that he was covering over there in the church. And the fact that we're not doing that is, I think, sort of shameful that in a country where we have vaunted civil rights protections, that we have attorneys general that are thumbing their nose at people of faith because they simply don't agree with their political ideology is absolutely shameful. And the same is true of those who would simply cover their tracks on their inequitable application by trying to simply curry favor and get the heat off their back, like the Biden administration tried to do, I think, with the indictments down in the cases in Florida. So the solution here is not to say, well, this law is unconstitutional, we better not use it. I think that the answer is actually the law is there, and until someone tells me I can't use it anymore by taking it off the books, I'm going to use the thing to protect the people of faith and pro-life people as well.
Well, I'm going to come back to, we're going to start our first questions here from the audience, and we have one from Charlie Eldred, and I'm going to randomly choose you, Aaron, for this question, the severability question, because we talked a little bit about the possibility that, like, well, maybe post-Dobbs, the abortion clinic portions of the law are actually problematic. If at least to the extent that they are based on sort of a 14th Amendment rationale. If you don't have that protection, or if you don't have that rationale,
Yes.
are those portions severable, and so that it becomes just a FACE Act that doesn't protect faces at that point, or kind of what do you do from there?
So I think that the question might be a little more complicated because you do have the underlying Commerce Clause rationale as well. And my understanding is most of the cases that Jeremy was talking about that upheld the FACE Act were prior to Morrison and Lopez. Now, some have been subsequent. The Commerce Clause is certainly not interpreted faithfully to the original understanding by any stretch. So I think you would still have an open question as to whether the FACE Act satisfies the Commerce Clause. But specifically as to the 14th Amendment, I think potentially yes. But as Matthew said initially, you would still have to show, in order for Congress to use Section 5 of the 14th Amendment, that there was a historical pattern of a failure to protect based on religious exercise. You might be able to get faith-based pregnancy centers in there because they are certainly most of them affirmatively faith-based, but that'd be a separate question. Certainly houses of worship will have a constitutional right, but whether that's something that the states are failing to protect, I don't think it's in the congressional record currently. Perhaps there is enough that it could be someday. But as the statute stands, I think it has an uphill battle under the 14th Amendment. And I don't think any court has upheld it on that basis. I could be wrong, but my recollection is no court has.
So we've talked several times actually about on the Commerce Clause point, and Matthew, I'll come back to you on this. We've talked several times about it. Can we drill down just very briefly? I mean, because I think probably a lot of people would be listening and maybe in it's such a sign of where our Commerce Clause jurisprudence is that that this would even get us this far in before we would drill down on this. But where exactly is the interstate commerce involved in people worshiping in a church? Or it's a little easier, although awkward, in the abortion clinic context, because at least there's an exchange of money often. In the church context, I don't know, other than tithing, it's sort of hard to figure out where that fits. What is the Commerce Clause rationale? Is it basically just the everything is commerce rationale?
Casey, I think that's all that I can say about it. Is the court has held that growing marijuana in your backyard for your own use is interstate commerce, because if you have everybody nationwide grow it in their backyards, then that would have an effect on interstate prices and supply and demand. I mean, this is, to me, just complete made-up interpretation of what interstate and commerce mean. I disagree with that precedent. Justice Thomas had it right. If Congress really wanted to be creative, they could probably regulate every potluck supper and spelling bee and the quilting bee in the country if they chose to do so. And I absolutely think that the FACE Act fits into that category as well. You're right. At least with abortion, at least there's a dollar sign somewhere that's required. It's archdiocesan annual appeal time, at least at my church. So the dollar signs are around with us too. But we're not charged for actually going there. In any event, it fits within the runaway understanding of the Commerce Clause, maybe, that's prevailed over the last century since the New Deal. I think it's absolutely bonkers as a matter of original meaning.
Yeah. Okay, so we actually sort of accidentally worked through several of your questions. So thank you for asking them. Do we have so Teresa Collette asked, she points to Mike McConnell article and asked, do we have a breakdown on the sentencing of defendants under FACE? We talked a little bit about that. Does someone want to sort of sum up kind of what has actually occurred under the FACE Act so far?
Yeah, I'll go first on that, and Erin can back up on some of this, because I think she's got some good experience here as well. Which the FACE Act itself says it has different remedies. For a first offense, you're going to be fined in accordance with the title and not in prison for more than 3 years. So a federal misdemeanor. If you have more than one conviction under this, now you're talking about jail time up to 3 years, and it is a federal felony at this point. So on the face of the FACE Act, no pun intended, those are the kind of the remedies that are available to you on the criminal side. Now, the civil side on this as well allows for the Attorney General of the state or the Attorney General of the United States or an individual to seek statutory penalties. So let's start with the individual. The individuals, if they're wrongly aggrieved, they can claim actual damages, meaning if you had a firebomb thrown through your window and burned down your pregnancy care center, you can recover the cost of the rebuilding of that project. And that whether that's $20 or $2 million, you can recover the actual cost of that. And that, of course, would be a question for the court and the jury to figure that actual damage amount out. Or you can elect to have a statutory damage. So if you don't have much damage, it's a spray paint that you've got to wash off or whatever it might be, you can elect a statutory damage of $5,000. That's the individual person that's doing that. And that's for every single person who has done it. So if there's 2 people, that's 5 plus 5, that's 10. You get to have that put against every single agitator that's caused you problems. The bigger hook on this, the bigger strength, I should say, is from the Attorney General of the United States and the Attorney General of the state, who are able to impose penalties parens patriae. They're able to invoke $10,000 for the first offense and then $25,000 for other offenses, and those are per offense again. So if there are 15 protesters, $10,000 per person. Someone do the math for me. What is that? $150,000, I think. I didn't go to law school to do math, so I think I'm right on that, but don't kill me if I'm wrong. That's significant. And those are statutory penalties that cannot be discharged in bankruptcy. And I can tell you from my experience in Florida, that is what led for many of the people there to be able to ultimately get a deal that they mediated with us, where we required them to plead to a felony, even though they were only entitled to a misdemeanor. They pled to a felony, and they had to pay our statutory penalties as well, because Ashley Moody had filed her lawsuit and held in the background a whole bunch of money that they were going to be subject to, that they feared more than pleading to a felony, giving up the rights to gun ownership and the right to vote and all the rest. So it has some real staying power here. And when, as you have in California and Minnesota, as I've said multiple times, AGs doing nothing to protect their citizens, where the federal government can now come in and say, we view these rights under the First Amendment so critical that the federal government is given the right to enforce these civil rights protections for people of faith trying to peacefully gather. Thankfully, there's somebody that can do it. We get rid of the FACE Act and we have other problems to be able to do so.
We're going to close here with Aaron or Matthew, either of you. If you want to, do you have an alternative strategy, I guess, on how do we deal with this problem of, these are very real interferences that can happen at with both of these things, and you've got both the churches and the clinics. How do we deal with that problem if not through having sort of the federal action from the FACE Act and the fact that you've got politicized prosecution happening, and that's just reality.
I'll end where I started, and I'll give Aaron time to finish as well. But I started with the Reconstruction era decision that said that you have to have state action before Congress can step in. That's not a correct reading of what the Equal Protection Clause says. The Equal Protection Clause says that every person is entitled to the equal protection of the laws. So I would overturn that and have there be more robust federal protection for individual rights when states fail to provide them. So I think that the answer to the sort of heavy indifference that we've talked about here, and states not getting off their butts and doing what they're supposed to, should actually be that people should have the ability to assert a constitutional right or through remedial legislation to do that. So I would go all the way back to the start and go to the text of the 14th Amendment and say the Supreme Court's got it wrong for 150 years.
Sure. And I would just, query again, like, why do we have to federalize everything? As we saw, like, there's absolutely no Commerce Clause hook. Like, that's just absurd. And so do we need everything to be, and I understand Matthew is talking about a different constitutional basis. But I would hope, and again, you can point to New Jersey, California, New York, and say this is a very real problem. So maybe Congress could make that record. But I would like to see those states have to be forced to actually enforce their laws. And then if they don't, maybe Congress can step in. But yes, agree it's a problem. We need to enforce state law. Not sure why it should be a federal law.
Thank you all. And this has been a wonderful conversation, and I will turn it back over to Elizabeth. And thanks again to FedSoc for hosting this discussion.
Yes, so Casey, Jeremy, Matthew, Aaron, thank you so much for sharing your time and expertise with us. And I want to thank our audience for joining and participating, submitting some really excellent questions. We also welcome listener feedback. You can send an email to fedsocforums@fed-soc.org. Thank you all for joining us today, and we are adjourned.